So I'd like to introduce myself. For those of you that have not been on this platform with me before, my name is Jill Summerlot. I am the webinar coordinator for InSource. I've been with InSource. This is my 23rd year. I do have a son. Well, I have three children, but my son is the reason how I got into the special education realm, and he actually just turned 27 last month. So he is an adult and works a full-time job and is a functioning adult. I don't know how else to put it, but graduated with high school with diploma. His diagnosis, if you want to call it a diagnosis, what his biggest concern or biggest challenge is that he does have autism. So he is an adult that is living in that world of autism and navigating through that as an adult. So a little bit about me. Welcome today. Thank you so much for being here. I greatly appreciate each and every one of you. Without you, this platform would not be here, because this is the way that I am going to move forward with how to present information and material for our parents. I will be doing webinars at least twice a month with Lisa Paddock, and those are on Thursdays. And then scattered throughout each month, you will see different times that I will be on. It'll be either during the day, it could be in the evening, it could be at lunchtime. So please, if you have any questions, you're more than welcome to reach out to me. And always, if you want to know what's upcoming, you could always sign up for our InSource In Touch weekly newsletter. So today we are going to talk about resolving disagreements between parents and schools, just like I had said. And it's a conversation that is sometimes a little difficult to have, but it's a conversation that needs to be had also. So let's kind of just jump right on in. Again, if you have questions, don't hesitate to put them in the question and answer box or in our chat box. And for those of you that are out onto our Facebook Live on Facebook, please feel free to put those in the chat box as well if you have any questions. Periodically, I will look over at my tablet to make sure that I don't have any questions that have popped up. For those of you that may or may not know, I'm not an attorney. InSource is not a law firm. We do not give legal advice. If you are needing legal advice, I highly encourage you to talk to a competent special education attorney and get some of those answers through that legal platform. I'm here just to give you information and give you some things that maybe you can think about. Our mission, most InSource employees are parents, or we have family members with disabilities. I would like to also remind you that all of our services are free. They're never a charge to any parents. We do take contributions. Those help us cover expenses that are not allowed through our grants. So real quickly about InSource, we were established back in 1975, and we are one of the first 5 parent centers in the United States. We do, every single state in the United States now has a parent training information center. And so if you ever move out of the state of Indiana, or if you're listening from another state, please just look up your parent training and information center. You will have one in your state. Some states have 2, some states have 3, some states have 4. I know that my daughter-in-law, special education administrator out in California last year, and they have 4. Now they've moved to Texas, and they have, I believe, 2 or 3 there. I can't remember. So there's always, a chance that there could be more. So how do we help? We assist parents by phone, by email. We can help you just by talking to you over the phone on how to maybe understand your rights and your responsibilities. Also to be able to help you to understand your students' rights and responsibilities. We do provide information about that special education process, and we do strive hard to help families and schools work together for those really good, positive working relationships, because we know that those relationships are 100% better when you do work together. So Article 7 provides steps for families and schools to follow when there is a disagreement that needs to be resolved. And there is a continuum of options that is in Article 7, ranging from, an informal request to a formal steps that a parent can um, utilize. So let's look at some of the more informal options first, because we really want to try and solve things at that lowest level possible before we would move up to some of those more higher restrictive, let's just say it like that, forms of the process. So resolving those disputes. So when parents and school and staff, when everybody does work together as a partner, that we do know that those outcomes are generally much more improved for our students. And we know that when we have those good communication and good working conversations, it's easier to really solve those disputes. It's easier to have those conversations when you've had such a good working relationships. Um, there's generally less stress, less tension. Students are, really maximizing those opportunities for success. We know again that the best outcomes for students is whenever we have those good working relationships. And think about how long you are going to be in that school system. For myself and my son, we lived in this community and we stayed in this community. And he started in preschool. So he went to preschool from 3 to 4, went to kindergarten at 5, and then he done his 12 years here at school, at the same school. So what you're really thinking about is, you're thinking about 15 years. He was in school in this same corporation for 15 years. That is a lot of years to have to work together with the schools. And you want to make sure that, that relationship is very lasting. It's very, I say open. It's one of those things that you can have a disagreement and agree to disagree. But whenever you are in that situation of long term, you've been here, you know the ins and outs of everybody that has worked with your child. And you know that those good, positive working relationships are always going to have better outcomes. Now, again, we're not always going to get along, we're not always going to agree, but once you have that foundation, then it's easier to be able to say, I don't agree. So those are just a few things that we know that can help with the resolving of those disputes. So those less formal dispute um, options that we have, if a parent disagrees with the proposed IEP or any area of disagreement, you can choose those informal options. You can choose to reconvene a case conference. You can choose to meet with the public agency representative. Now, if you don't know who that public agency representative is, pull out your IEP, look on the list of people that were in attendance, pull out the invitation that you received, and it will have the public agency representative listed there. It could be the PAR. It just depends upon what they call that person. The acronym is PAR, P-A-R. It could be a building principal. It could be a special education director. It might be an assistant director. So you need to find out who that person is, if that's the person that you would like to meet with. Um, if you're in a new school district, or if you're going to withdraw and go to a different school, you're going to want to have that ongoing working relationship, because those things are going to need to be sent to each school. It will need to be, things are going to need to be transferred. conversations are had, things like that. Um, the dispute resolution process does have the tendency to increase complexity. So those informal options, they really work best, and they really work at preserving those relationships. Um, you can ask to meet with staff at any time. Maybe you want to just ask if you can have a staffing. Maybe you just want to meet with the teacher of record and maybe get some things cleared up. You can always email and ask for questions as well and say, here are my questions. Do you mind if we have either can we reconvene the case conference? Can we just meet in person and you and I talk? It's really how what your comfort level is with, but always know that solving those things at the lowest level possible tend to have better outcomes. You're not required to, use those less formal options, but you might want to consider them, especially before you file that complaint, before you go to mediation or that due process hearing. Just again, this is a process that, as a parent, I think that you really need to sit and consider and think about, because it's not something that you should go into lightly whenever we're thinking of any sort of dispute resolution processes. We really need to sit and consider all of the options. We also need to consider what the outcomes could be and what the retribution may be for that. So it's one of those things I ask parents whenever I'm working with them. Please take the time. Please, again, if you want to talk to a competent special education attorney, please do that. Always know that that option is available to you, but also think about, you know, um, whenever we're angry, we're sending an email or something, we always say to don't send it till the next day. Wait till you've had time to cool down, go back, reread it, and then if you still feel the same way, send it. So that's really how I tell parents, let's take a cool down period here, and let's, really think about this, and maybe even write out the things that you're not happy with, or the things that you are in disagreement with, and look at them on paper. Those are just a few of my suggestions that I have for parents, because sometimes they can get the water can get very muddy whenever you're in those high tension settings. So we're going to review those more formal dispute resolution options. And so as you see on the screen, we're going to cover those: complaint, mediation, due process hearing, and that resolution session, and even a civil suit. So a person or organization um, filing a complaint doesn't have to be a parent. So it could be your nanny. It could be your doctor. Um, it could be we as in-source staff do not do that. Those are things that are left in the hands of the parent. So we can give you the information on where to find the information on filing a complaint, but those things are in your hands as a parent. A complaint issues, those are violations of Article 7. If you don't have a copy of Article 7, and by the way, it has been reauthorized, so there are some updates to Article 7, and hopefully we're going to get further down into the summer, fall, and we will be putting together a webinar with those new updates. But if you don't, I highly encourage you to go to our website and download a copy, or go to the Indiana Department of Education's website and download a copy from there. So it could be any of those violations from Article 7, or it even can be from IDEA. That's the federal law, and that is also the Individuals with Disabilities Education Act. So it could be either one of those that you could file a complaint on. So how I explain it to parents is, if you're thinking about filing a complaint and it's written into the IEP and it's not being done, it's a matter of fact. So think about it like this. Little Janie is supposed to be receiving 30 minutes of reading, and she's not receiving that. So it's a matter of fact, she's not receiving it. It's written into her IEP and it's not being done. So those are kind of some of the things that you can think about that on maybe how to decide if you're going to file a complaint or you're going to just have a conversation. There's some other examples is the school changed the placement without providing you as the parent with any prior written notice. Maybe the schools failed to conduct an evaluation and convene the case conference committee within the timelines. Again, it could be that you, as a parent, you feel like that they've not done any of the services that's written into the IEP. It could be a failure to comply with a mediation agreement. And that's an agreement that's been reached during a resolution session or, something that's been enacted by an independent hearing officer. So the complaint has to allege a violation that occurred within 1 year of the date of the complaint. And it has to be received by the Department of Education. So that complaint goes to the Indiana Department of Education, and you see on the screen that there is ICHAMP, and ICHAMP is our process that you go through to file that complaint. So when you're filing a complaint, basic complaint requirements are noted on the side, and they do keep documentation to support your complaint. You want to think about what kind of recommended action you would want to have them to correct the violation. And, there's some examples are parents, they just ask to have services made up or have that lost instructional time made up as appropriate. So you're trying to, when you file that complaint, you are going to want to make sure that you know um, what those resolutions that you would like to have in order to fix it. You want to also make sure that you're keeping those documentations so that it can support your complaint, and so that's, filing, whether you're keeping your child's IEP, whether it's notes, things that you received from the staff. It could be so much as even um, the update on goals. So, just make sure that you're keeping all of those things so that you have that if you were going to file a complaint. So Article 7 gives schools the opportunity to resolve that complaint. And so they're going to try to resolve it at a local level. So your director at the local level, they may respond in writing to a complaint, and they will have that send to, um, they can respond to the Indiana Department of Education, that Division of Special Education, and be able to decide if they are going to, yep, we're going to try and work it out, or no, go ahead and we will, you, complaint investigator, you go ahead and investigate it. So the local director may work out a written agreement with the complaint and with the complainant and forward that written agreement to the Division of Special Ed. Or you can agree with parent to go to mediation within 20 calendar days of receiving the complaint. It just depends upon how you are going to move forward with your complaint. So you have the department of the director can say, yes, we're going to work it out, and they get back with you and ask you to help resolve it. They can go ahead and let the Department of Education investigate it, or they can say, we can agree to go to mediation. So those are some of those options that would be coming up in that first 10 days of your filing. I'm sorry, I thought I seen a question pop up. So after the investigation, the complaint investigator will issue a report when that's going to happen within 40 days. And the complainant and the school are notified by the complaint investigator of those results. There will be a corrective action plan that may be put in place for the school. And there are also maybe timelines that will be attached to that so that the school can complete that corrective action and monitor that progress and compliance with the corrective action. Now, a failure of them to comply, that can result in withholding of funding to public agency. In 23 years, I have yet to ever see anything like that. Doesn't mean that it didn't happen. I just don't know about it. But as far as I know, I've never seen or heard of that. It's one of those things that you have the right to file the complaint. You have the right to have that discussion on, what the complaint investigator found. You have the right to be able to, go sit down and back into a case conference and say, all right, here's the corrective action. Let's move forward. And what are we going to do with it? I do want to point out one thing. When you file a complaint, and please don't think that I'm trying to say don't file a complaint, but when you file a complaint as a parent, remember that you have no decision making on any of those outcomes. So I explain it to parents as your opinions, your thoughts, your how you would resolve it, or conversations, excuse me, that you may have to try and resolve it. Those are not considered. So it's the complaint investigator that's going to do the corrective action plan. So what I'm really trying to say is you have no say so in the outcome. So just remember that, because you want to make sure that you are still part of the processes. You want to make sure that you still have a say in things. But when you do file a complaint, neither you nor the school has any say so in that. It's completely up to that complaint investigator. So, it's one of those things that if you're going to file a complaint, I ask parents to please, let's consider what we could do prior to that and to see if we can't fix it before we move to this, before it's out of your hands. So that's all that's just, trying to settle it as the lowest level possible as we can. So what if a disagreement with the complaint, what if there is a disagreement with the complaint report? So, either side can disagree with the findings, and so they may request for a reconsideration, but it has to be filed within 10 days of receiving that form. The 60 calendar day timeline, that does refer to the entire complaint process and that includes that reconsideration time. So remember that you've got this timeline that you're also working with. And all of those timelines are in Article 7, or you can get a copy of even our Navigating the Course. And that's on our website, and that's on the Indiana Department of Ed's website. So you can always get a copy of that Navigating the Course. So all timelines are held within that, both of those documents. So the 60-day calendar timeline, that does refer to the entire complaint process. And again, that's from beginning to the reconsideration. If changes are made to the original report, the Department of Education, they will issue a revised report. But if no changes are made to the original report, they'll send a report to all parties indicating that no changes were made. So mediation. Navigating the Course does describe mediation as a voluntary and confidential process, and this does allow parents and schools to attempt to resolve their issues with the help of a trained impartial mediator. The goal of that mediation is to find a solution that meets educational needs and it meets the needs of the child. The mediator helps the parties to communicate with each other. They are not part of the decision-making process. They're not a stakeholder. They have no, they don't have anything in the game here. It's completely between the school and the parent. That mediator is just simply there to try to get both sides talking and trying to get you to come to an agreement. Now, again, at this point in mediation, you as a parent, you still have the opportunity to have say so in the outcomes, because you and the school must, either come to an agreement or you don't come to an agreement. It just depends upon what you have decided as a parent and what you're actually mediating on. It's one of those things that nobody can predict those outcomes. Um, if you do come to an agreement, then there is an agreement that is signed by both parties, and this is legally binding. And so it is enforceable by any state court, any district court, or of the United States. A complaint can be filed through IDOE if mediation agreement is not followed. So you do have a recourse if for some reason that you do go to mediation and excuse me, the school fails to implement that, then you would have a recourse to file for a complaint. Now, mediation is also the forms and everything. It can be, like I said, initiated by the parent, but you go to the iChamp, and that is where the area is where you would find to fill out the paperwork for going to mediation. I will tell you that mediation is one of those things that a trained mediator is sent down from the state. Again, that mediator is just there to get you both sides talking. It could be a case of that the mediator sequesters, everybody. It could be that you're sitting there in the room in front of everybody the whole time. It really just kind of depends upon what the mediator feels is in best interest and how to move forward within the confines of mediation. Mediation, it can help resolve, the several things that are on the screen that you see up here. It could be that eligibility. It could even be how appropriate was that evaluation? How appropriate are the placement for these things? So you can see how it can help whenever there is a disagreement with these things. Um, it's again, I hate to think that I would be trying to persuade somebody not to file. I just want to make sure that a parent understands all of their options if they choose to file. So again, even though mediation is, both sides have to agree to go to it. Both sides have to agree to the agreement that is made in there. Just remember, think about, or you would say, I want to go to mediation. Take time to digest the process, take time to be able to even understand what it may be that you need to go to mediation for. And so just keep those things in mind whenever you're trying to make any of those decisions. So let's jump into due process hearings. So hearing officers, they do have to meet specific training requirements, and they're generally administrative law judges, and they're qualified to they're qualified to render those decisions according to the standard of legal practice. A parent or a student that's 18 or older, school or even the Indiana Department of Education may request a due process hearing. So that request can be made electronically, again, through our iChamp system. It's at the Indiana Department of Education. You can go through that system in order to file for that. If a parent challenges the implementation of an IEP by requesting a meeting or mediation, and that method doesn't resolve the issue to the parent's satisfaction, the school may implement the IEP on the 11th instructional day after the meeting or mediation, unless a parent requests due process. So remember, there are some timelines here, and so we need to make sure that, again, as a parent, you understand what those timelines are. And as I do this webinar, I don't mean to leave out schools. And so if there's school personnel here, or you're in another field that you're here as a professional, I'm not trying to leave you out. I'm just really wanting to make sure that parents understand what their rights are as far as any sort of dispute resolution. And quite frankly, that if you are a school corporation and you're here, you have the same rights as the parent does. It's just you are the school. And so please don't think that I would take away any of those rights for either side. It's just I like to make sure that parents have a complete understanding so they can make a clear and concise decision. So the due process hearing request, um, that alleges a violation that occurred not more than 2 years before the date the parent knew or should have known about the alleged action. So you have 2 years that you are alleging that the infraction happened. You have to have specific misrepresentations by the public agency that it had resolved the problems forming. So the basis of the due process hearing, or the public agency's withholding of information from the parent that was required under this article to provide to the parent. So there are some very hard, fast rules, and that's why I say that if you, especially if you're going to do process, you don't have to have an attorney, but you may want to just have a conversation with a competent special education attorney. Because quite frankly, they know the ins and outs of filing any of that paperwork that you may need as far as going into that hearing. So after a due process is made, that independent hearing officer is going to be appointed, and they're going to take jurisdiction over of the entire process. They are the person that's going to issue the subpoenas. They're going to be the person that frames and clarifies any of the issues, and they're the ones that are going to be issuing the rulings. So again, that conversation is you are no longer in control of the outcomes. That is 100% in the hands of that independent hearing officer. So, again, I probably sound like a beating a dead horse here, for lack of a better term, but I just want you to understand that you no longer have any sort of control over those outcomes. So if the due process hearing request was made by the parent, the school has to contact the parent for the various reasons that are up here on the slide. The school will have an attorney present at the hearing. Again, a parent, you are not required to have an attorney to represent you, but due to the complexity of the legalities and the nature of the proceedings, an attorney who is a competent in special education law may have some significant benefits. So just, again, part of that decision-making process and having a very clear understanding of the process and making sure that you as a parent have a very clear understanding of what the outcomes could be. And so you can make a very clear and concise decision on how that's going to benefit your family or your child. The 15 calendar day timeline, that's for a resolution meeting to see if there's any way that you can resolve those issues without going to moving forward to that due process hearing. So you do have an opportunity, I call it the last ditch effort, to get to have another conversation with that public agency representative. And generally at that point, that is your special education director. And so you're going to have a conversation on trying to resolve those disagreements before you actually walk into that due process hearing. Doesn't stop. The hearing does not stop unless you do reach that agreement. So please don't think if you go to that resolution session that it's going to stop any of the processes. No, but if you do come to an agreement, then yes. So that resolutions, again, that session is to attempt to avoid that adversarial hearing. If if the parties come to an agreement within that resolution session, then there is a written agreement. It's signed by both parties, and that is also legally binding, and that's enforceable by the state court or your district court of the United States. A complaint can be filed through IDOE if a school fails to follow that resolution agreement. And the resolution meeting, it's going to include a representative from the public agency. Um, they this isn't a case conference. So the resolution meeting, it has to include a representative of the public agency that has decision-making authority on behalf of the school. So that's why that person is so important to be there. And that's why I say generally it is a special education director, because they're the ones that are there to speak for all of those funds. The school, they may or may not, they may not have, I'm sorry, they may not have an attorney unless the parent's accompanied by an attorney. I highly encourage you to not go in with an attorney, because you want to have a conversation. And this is where a conversation can get rough. This is where a conversation, you can go in and and it's raw, is what it really should be. It's not rough, it's just raw. Let's just get down to the brass tacks. Let's talk about what is needed and see if we can come up with an agreement. If the public agency isn't able to do that, then absolutely you just move forward to the next step, and that will be that portion of the due process hearing. So if the public agency is unable to obtain the participation of the parent in that resolution meeting, there has to be a reasonable effort made to try to get a hold of the parent. And so they need to make sure that that is documented very well. And the school may ask the hearing officer to dismiss due process hearing case. So if they can't, if a parent does not work as far as coming to that resolution session, or they're unable to get them to even contact them, then the school could ask for that to be dismissed. If the public agency fails to hold or participate in the resolution meeting within that 15 days of receiving the notice of the parent's due process hearing request, the parent can ask the hearing officer to begin the 45-day calendar timeline, so it speeds it up. So the public agency does not have to convene a resolution set meeting if they initiated the due process. Again, see, this really can get very thick in the weeds. That's why it's so important that it's not something that somebody just throws out. I'm going to mediation, I'm going to due process, because there are things to think about. There are things to consider, and want to, again, have all the information so that you can make that very clear and concise decision. So parents need to be aware when hiring an attorney at the school. They have attorneys on staff, and they may also hire outside attorney with expertise in that special education arena. Um, if the parent seeks legal counsel, their attorney will need to be educated in special education law, and parents are not required to hire an attorney. So parents' rights in a due process hearing are similar to court proceedings, and the hearing officer makes those legally binding decisions. So again, we're talking about a situation where if you're a parent and you are filing for due process, you did not come to an agreement in the resolution session. So the hearing officer is the one that's going to be making those decisions for you. So again, you are completely taken out of that consideration of anything. He or she is going to make those decisions on what they think. The hearing officer's decision is based on those oral testimonies and any of that written evidence. The hearing officer really is very similar to a judge. There is no jury, but it's very similar to the judge. If the decision of the parents to decide if the hearing will be open or closed to the public, it's also their decision to have the student attend or not if the student is under 18. Now, I have been to 4 due process hearings in my time, and 3 of them were open to the public and 1 was not. So, I mean, it just really depends on what the parent wants. And, you know, it again, that's another part of that decision-making process as a parent whenever you're thinking about filing for due process. So that judicial review, so those disagreements with due process decisions, how many days do they have to schedule the meeting? Okay, so let's go back, if you don't mind. So when you go back and you do file for that due process, then the school, I went too far, they have the 15-day calendar day. So that's the timeline for a resolutions meeting to see if the issues can be resolved. So they have, they offer that resolution meeting 15 calendar days. I hope that answers your question. And I just want to point out, you guys, again, that QR code has all of these slides and things in it. So please, if you, and I'll put the QR code back up on the screen before we're done, but that will all be in there with all of the information that we're talking about today. So at the end, and we've only got about 12 more slides to go. So that all can be in there. So let's go ahead and you're welcome for that. If you have any other questions, please feel free to let me know. So the judicial review, so any party disagreeing with the decision of that independent hearing officer, they can file a petition for judicial review within that civil court. And that's within 30 calendar days after the independent hearing officer's written decision is received by everybody. So you got 30 calendar days. It can be initiated again by either party. The appeal cost is paid by the prevailing party. And this is really the most extreme option for parents and schools, and it's not commonly used. And cases can go all the way to the Supreme Court. You can get in several different law books you can get online, and you can see different Supreme Court cases that have come from parents. And there used to be a law conference every year, and we used to get some of those cases. And it's been a couple of years since we've been to a law conference, and so I'm really not sure off the top of my head any of the names that I would know. So federal law. So parents need to be aware when hiring an attorney. Schools, again, they have their attorneys on staff. They may hire outside attorneys themselves. If the parent seeks that legal counsel, their attorney, they'll need to be educated again on those special education laws. But you as a parent are not required to hire an attorney. Parents' right in a due process hearing are similar to a court proceeding. The hearing officer makes all of those legally binding decisions. The hearings officer's decision is based on oral testimony and written testimony, and the hearing officer is very similar to a judge. So if the due process hearing is requested by a parent, the hearing shall be conducted, and that final written decision, so that decision of that outcomes, that will be received no later than 45 calendar days after the 30-day resolution period. So the 45, and see this again, this is where we're kind of thick in the weeds here with all of these timelines, and that's why it's so important that we make sure that this is an outcome, or this is a decision that you want to make. So the 45-day timeline that occurs, that it commences the day after both parties agree in writing to waive the resolution meeting, that both parties agree in writing that no agreement is possible, and that either party withdraws from the mediation process. Now, as a parent, if you fail to participate in that resolution meeting, that's going to delay those timelines for the resolution process and the due process hearing until the meeting is held. So the hearing officer's decision will be considered final unless that petition has been filed by judicial review. And again, that is that after that hearing officers rendered their decision, and it's a 30 days of the receipt of that hearing officer's written decision. Or it could even be an electronic. It could be an electronic decision that you get. So it could either be written or maybe it's going to come in your email. So you have that 30 days. So real quick, we have 9 minutes. And so real quick, we're going to just run through some scenarios. And if you want to put the answers in the chat box, or you want to in our Zoom platform or even on our Facebook Live, please feel free to. The first one is this a complaint or is this due process? My child has 30 minutes of speech therapy per week in his IEP. They're only receiving 15 minutes per week. What do you think? Complaint or due process? Anybody want to weigh in? So remember what a complaint is. A complaint is a matter of fact. A complaint can be filed on any of those things in Article 7 that a school may not do. Or it could be against the IDEA. So this would be a complaint. How can we receive a copy of the presentation? So you can get a copy of this whenever I put the QR code up. And Stacy, thank you very much. You were correct. It is a complaint. So number 2, thank you, Sue, on Facebook Live. It is a complaint. Thank you very much for playing along. I want to play. Everybody wins. So my child is in a self-contained classroom with students of various disabilities and is not progressing. So what do you think? You know, it's really expected that students make progress in their goals, and those are written into the IEP. And so disagreements between parents and schools about that lack of progress or what constitutes adequate progress towards goals, that can be considered in a due process hearing. So, but you can also resolve those things in a case conference. You resolve them in mediation or a resolution session as well as a due process hearing. So again, something like this, with this question here, it could be various ways of resolving. The IEP has identified the student as one who needs one-on-one assistance. This assistance is being provided by a peer because there's no money for an aide. What do you think? What due process? So it's really important for parents to understand the need for the IEP to be written specific. So it has to, you know, there has to be a discussion on a one-on-one assistance during that case conference. It should address who and how is going to provide the assistance, because one-on-one assistance can be provided by a teacher's aide, a peer, tutor, or others. The IEP specifically states that one-on-one assistance will be provided by school staff. So if they fail to do that, it becomes a complaint. Okay. Number 4, the IEP says that my child will be in a resource room for 30 minutes daily. They are receiving no services in the resource room. Now think about this one here, because we're talking about a student's least restrictive environment. So if a student's LRE is a resource room, the IEP that should specifically say what supports and services that they'll be receiving in that setting. So alleging that the school is failing to implement those supports and services in the resource room for the IEP would give the parents the option to file that complaint for not following the IEP. Wanted to make sure we didn't have any questions. So at my child's case conference to review their special education evaluation, the school says that they do not qualify for an IEP. I don't agree with the school. They want to wager in on this one. So when you think about this, we're talking about a determination of eligibility for services. This is made in a case conference by a case conference committee. So if a parent disagrees with the school's findings on eligibility, the parent has the option of requesting mediation and or due process. A student is identified as orthopedically impaired. They have developed problems with reading, but the school is denying the reading services because they are not related to the orthopedic impairment. What do you think about this? So the child has an orthopedic impairment, but there's some issues that have arisen with reading. Good. So Article 7 states that a case conference committee has to determine the special education and related services that will meet the unique needs of the student, regardless of the student's identified disability. So if there's a reading problem or other problems that are not related to that qualifying category, then it has to be considered when developing the student's IEP. In order to receive any services, the parent will need to bring these unique needs to the attention of the case conference committee. So this would be a complaint. So in summary, we have 3 minutes. So in summary, rather than proving someone is right and someone is wrong, it's much better to work together to find a solution. And again, we really want to focus on the needs of that child, and the attention should always be upon what that child needs. You can absolutely, you have the right to file a complaint. You have a right to mediation. You have a right to due process. You have a right to that resolution session. You even have a right to judicial review. As a parent, please take the time to consider all of your options before you just say, I'm going to mediation. You want to keep all of your, um, you want to keep everything intact. You want to make sure that that relationship stays intact, because think again about how long your child will be in that school corporation. Again, I'm not saying that not to do it. I just want to make sure that you as a parent make sure that you do consider all of your options first. Okay. We do have a volunteer program that if anyone would like to have further information on, you can absolutely let us know. You can contact us at any of the numbers or any of the online platforms. You're more than welcome to reach us there. You can email me directly. My name is Jill Summerlot, and I am listed under the staff of, if you look under the staff, I'm in the coordinator section of our website. If you want to find a liaison that's in your area, please feel free to use our website and go in there, and you can put your zip code or your county and your address, and you'll be able to find your local liaison in your area. Here is that QR code. Please, if you need any of those resources, you're going to want this QR code. I really, really need for you to do that training sign in for me, because we are federally and state funded through grants, and they ask us to make sure that we are having, I have to report that I've done my webinars, and I've had so many people in attendance, and I also have to have those training surveys to make sure that I'm either doing a good job or I'm not doing a good job. So please, I really, really need for you to fill those out. If at any time again that you have any questions, you are more than welcome to reach out to me. I'm J Summerlot, SUMMERLOT, at insource.org. So please feel free to reach out to me. Again, that QR code that you see here, excuse me, that will give you the information that you need, that signing, the resources, the survey, even that certificate. And if you're watching this and you've made it this far, and you're watching it on our YouTube channel, and again, you've made it this far into this, I really need for you to do that too. Even if you're just watching the replay on this, if you would please make sure that you do the training sign in and the training survey. All right. I don't see any more questions. I greatly appreciate each and every one of you for being here today. Please know that I really need your support. This is how we keep moving. We get information out to parents, and between everybody that's here today, now you're really a little bit more empowered, because I hope that you have gotten a little bit more information. So anyway, I will not take up anyone's time. It is 1:01. I'm into 1 minute of your time. Thank you again. You have an absolute wonderful weekend. And everyone, I will see you next Thursday.